Welcome back. Welcome back. Uh, in this lecture, we will shift our focus to categorization and types of rights to theories of rights. What kind of theories of rights have been given till now? We have seen liberalism, we have seen Marxism, we have seen communitarianism, we have seen post-colonialism as well. We are yet to see multiculturalism and human rights debate. Right. So theories of rights is these four five types, and theories of rights have been in liberal idea as well. Right. So we will first shift. We'll try to understand what are different theories of rights. So first theory of right was divine rights theory. Who was who was origin? Let me make a proper table for this types types of rights and origin of such rights. Right. So, divine rights theory, who will be origin of divine rights? God will be origin of divine rights. Then natural rights, who will be origin of natural rights? Nature, right? But nature, by nature, I mean reason. Reason is the nature, is the origin of natural rights, right? Then fundamental rights have origin in constitution. Legal rights have origin in law, right? There is difference between constitution and law. Then moral rights have origin in society. These are different kinds of rights with different sources, right? Debate is with respect to not this, that what is a type of right and what is the source of it. Debate is with respect to how to rights and why to rights, and even debate is on if rights are needed. Debate is not on origin or type. Debate is on very different reason. Is right needed? Why right needed? And whatever conception of right that is being formed, is it the good conception or bad conception? That is the idea. So debate is totally on, is right needed and what kind of right is needed. So in start of that debate, we'll try to understand, in every debate we'll first understand liberal discourse. Liberal discourse first. In every theory we understand liberal discourse first. In liberal discourse, who was the first person to talk about rights? It was Locke. Locke, in his book Treatise on Government, gives theory of rights, whereby he says that there are three rights to human being, which is right, right to life, liberty, and property. For Locke, property is the most important right, because property is personification of man's work. Right. So for Locke, property is the most important right. Later, Mill said freedom of speech and expression, right of freedom of speech and expression is the most important right. Mm, right. And the next person who talked about rights in liberal discourse was Hannah Arendt. Hannah Arendt was not liberal per se, but we can categorize her like this. Hannah Arendt talks about not right, but right to have rights. Most important right for her is right to have rights. Then Rawls. Rawls gives his theory of justice, and Rawls give rights in form of difference principle, whereby public policy should lead to greatest advantage to least advantage. Against Rawls' theory of justice, against Rawls' theory of justice, Nozick gave his rights-based theory of justice, and Nozick defined justice as right to property. He gives the three principles: just acquisition, just transfer, and just rectification. Right? Just rectification. All these theories from Locke to Nozick, we see utility as a common criteria. Right is somewhere, some word based on practicalities, utilities, not liberty itself. Right? Not liberty itself. Against all this, in liberal discourse I am talking about, we have not shifted to other discourses. Within liberal discourse, the utility as a principle of having rights was changed by Dworkin. And Dworkin says that rights prevail over all other considerations. Right? I will write will rights prevail over all other considerations. What does this mean? This means that this means that rights prevail over equality, rights prevail over justice, rights prevail over everything. Rights is the most important thing. Dworkin said that rights are trumps. What does this mean? Over all other consideration, rights are the most important. Rights prevail over all other considerations. What are all other considerations? Liberty, equality, justice, etc., etc., etc. Right? Without right to liberty, there is no liberty. Without right to equality, there is no equality. Without right to equality before law, there is no justice. Right? So right are trumps. This means that rights are the most important consideration. Rights are the most important virtue that a state should have. Why rights are trump? Right? Rights are trump. Why? Because rights protect dignity. Right? Rights protect dignity. Rights rights are autonomy of self. Rights are autonomy of self. Why they are autonomy of self? Because rights talk about individual, and rights talk about rights talk about individual power on state. Right? So right are aligned with core principle of liberalism, which is autonomy of self. Right? So that is the idea behind why rights are trumps. First, because rights shall prevail over all other considerations, and rights protect dignity, and rights are aligned with core principle of liberalism, which is autonomy of self. Because rights rights are claims of individual over state. Then then people criticize Dworkin as well. You see criticism of Dworkin. Right? In criticism of Dworkin, uh, Sain suggests, right? Sain says, or other scholar says that first, Dworkin is deontological. right? This is criticism, right? Scholars suggest that Dworkin is deontological. By deontological, they mean he's impractical. Why he is deontological? Because he says rights are the most important considerations. He is deontological in terms of rights. He says rights is the most important thing. That is why he is deontological. And deontological people are impractical. This is his criticism, right? I don't believe in it, but still we have to write. So, scholar says that he is deontological. That is why he is impractical. Against this deontological nature of Dworkin, Amartya Sen suggests realization focused approach. Realization focused approach. What it basically means in terms of rights, right? What it means in basically in terms of rights, that in every situation, judiciary can interpret things to its own liking, right? If you start applying your logic in every context, in every situation, what it leads to extreme power in hands of judiciary, right? But it is still the solution of Dworkin's deontology as given by Singh. He says that in every situation, in every situation, judiciary should adopt principle of proportionality. Right? This is the idea. How does scholar criticize Dworkin? By saying that he is deontological. By saying he is deontological. He is deontological. He is deontological. That is why Sane suggests rights should have realization focused approach, consequentialist approach. Consequentialist approach means that in every situation, judiciary should and would apply specific logic, specific principles of justice. That is principle of proportionality. What is principle of proportionality? That with respect to the situation, judiciary should have proportional approach to it. Right? So so this is the criticism working, that is deontological, and solution as given by Sane, that is realization focused approach, principle of proportionality in judiciary. That is the idea of liberal discourse of rights, which starts with utility and ends with rights as terms as explained by Dworkin. Right? Then we move to next theory of the theory of rights, which is theory of natural rights. Theory of natural rights. What is theory of natural rights? What is theory of natural rights? What is natural? Right? We'll go back to that. Rights. Let's leave everything else. We'll go back to what is natural. Natural means by reason, by nature. By nature in political science means by application of reason. Never forget this. Natural will mean only one thing in political science. It will mean only one thing, which is reason, which is application of reason. Whenever you see the word natural, it is reason only, right? It is reason only. We apply reason to something or someone to get a particular theory out of it, right? Natural law. is based on reason, right? Whatever, if you find something with natural with suffixed on it, you will say application of reason. So theory of natural rights is 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 on basis of reason. It is on basis of reason. Then who starts and who gives theory of natural rights? It is Locke, right? It is Locke. Locke is father of natural rights. Locke is father of natural rights. And what does Locke say? That you have naturally given three rights of life, liberty, and property. These are natural rights, right? What is the origin of natural rights? It is reason. Keep this in mind. Reason is the source of natural rights. Whatever whatever natural you will write hereafter or even before this, always remember reason is the source of that. Reason is the source of that every time. So natural rights source is reason. Source of natural rights is reason, right? Source of natural rights is reason. What reason? Natural reason. By reason, you apply your intuition on a particular issue and get a particular principle out of it. Intuition is the source. Institution is not. Right? Human right as a concept is very is it is very natural to have. It is very reasonable to have. Right? Even without UDHR document, we know human rights were there. Right? We know human rights were there. So this is natural rights. What is natural rights? Rights which emerge out of reason. Rights which emerge out of reason. Then going ahead, we'll have to understand. We'll have to understand basis of natural rights as well. Basis of natural rights or basis of application of reason. Basis of application of reason. The first basis of natural rights is contract. Contract, as given by John Locke. John Locke says you have rights. You have rights because you have made contract with the state. Right? He says that you have delegated three powers to state, which is legislation, execution, adjudication. Other than this, all the powers lie with the people. And you have three fundamental natural rights, which is right to life, liberty, and property. So your possession of rights is based on the contract which you made with state. Right? What does contractual theory of basis of rights say? It basically says that your possession of rights is due to contract that you made with state. Right? This is contractual basis of natural rights. Then teleological basis of natural rights. This was given by Thomas Paine, one of the founding fathers of United States of America. Right? Thomas Paine Remember teleology. What is teleology? What is teleology? Teleology is final cause, right? Teleology is final cause. Teleology is conducive environment. Teleology is Aristotle's theory. Keep that in mind. What does teleology mean? Try to remember it. Who was Thomas Paine? Thomas Paine was one of the founding fathers of USA, and he gives teleological basis of rights. For Thomas Paine, social contract is stupid. Social contract is stupid. Why? Is stupid is illogical. Why? Why social contract is stupid or social contract is illogical? Because because social contract is made with particular generation in mind, right? Social contract is made with particular generation in mind. So Hobbes' social contract was relevant in his time. Locke's social contract was relevant in his time. Rousseau's the same, Plato the same, Machiavelli the same. Their theories, their theory of political system remains relevant to their time, right? So social contract or a particular theory, social contract is stupid and social contract is illogical because it is written in keeping particular generation in mind. But future generations, future generations are not, are not, or should not be limited to the contract which their their forefathers formed, right? Right. Social contract is written with keeping a particular with a uh, particular generation in mind, but this social contract will limit the incoming generation, the forthcoming generation should not be limited to the contract of previous generation. So he criticizes social contract, and that is why he criticizes contractual basis of rights. Right? Thomas Paine is against Thomas Paine is against social contract, and that is why he is against contractual basis of rights. He is so much against social contract that he says social contract is eternal clog. Social contract is eternal clog on the wheel of progress. Right? He says that I am just trying to connect why he is against contractual basis of rights, and he criticizes social contract to be eternal clog on the wheel of progress. Thomas Paine, in his book Rights of Man, he criticizes social contract tradition and says social contract is eternal clog on wheel of tradition. Why? Because it does not take into account future generations. So social contract he criticizes, and he gives teleological basis of rights. What is teleological basis of rights? We are going to understand in his book Rights of Man. In his book Rights of Man, Thomas Paine gives teleological basis of rights. What is teleological basis of rights? What is teleology? Teleology is final cause. Right? Remember Aristotle. It is final cause. And what is final cause? It is actuality. So what what Thomas Paine essentially want to say is that rights are necessary condition, or rights form conducive environment to convert potentiality to actuality, right? That is why rights are needed. Why rights are needed is not because of social contract, is not because of previous generation has made a contract that a particular generation will have rights, but because rights form conducive environment to convert potentiality to actuality. Right, right. That is the idea. That is the idea. Remember positive liberty. Remember T.H. Green. T.H. Green says that state will do capacity building. State will do capacity building. How does state will do capacity building? By rights. Human consciousness postulates liberty. Liberty involves right. Right demands state. So T.S. Green also gives teleological basis of rights, whereby he says that to develop capacity, to develop liberty, we need right, and for right we demand state. Human consciousness postulates liberty. Liberty involves right. Right demands state. Teleological basis of rights. Right. So this is the idea behind natural rights. This is the idea behind natural rights, whereby people will say that reason forms basis of natural rights. And if reason form basis of natural rights, what is the procedure? The procedure is of two types. Either it is social contract, whereby you make a contract with the state and you delegate three powers to state and you keep every other right to yourself. Contract. Or you give all the power to state and only keep one right to yourself, which is right to life, as given by Hobbes, right to preservation of life. Teleological basis says that social contract is stupid because it takes into account only one kind of takes into account only one generation. Hobbes' social contract cannot be applied in Locke's time, and Locke's social contract cannot be applied in Hobbes' time, right? So social contract keeps only one generation in mind. If it keeps only one generation in mind, future generation should not be limited to such social contract. And what should be the basis of rights, which is not social contract? It is basically teleology. We should give such rights to people which should and which can convert people's potentiality to actuality. That is the idea behind natural rights. Two types of procedures to get towards natural rights, either through contract or through teleology. That is the idea, right? The relevance of natural rights. Relevance of these natural rights we also have to see. American Revolution of 1776. American Revolution of 1776 said rights are self-evident truths. Right? Rights are self-evident truths. American Revolution of 1776 started the tradition of rights, right? On on the basis of rights, they were they were able to fight war of independence, and they were able to get their independence. So American Revolution and Declaration of Rights say that rights are self-evident truths and we have particular inalienable rights. Among these are life, liberty, and pursuit of happiness. This pursuit of happiness is we are going to understand in international relations what kind of interpretations Americans have done of this pursuit of happiness. You are going to be laughing on that. This Declaration of American Independence was written by Thomas Jefferson. Thomas Jefferson, slave owner Thomas Jefferson. Good man. So, relevance of American Revolution with respect to rights is that they wrote and they understood rights to be self-evident truths which are which are endowed by the creator on the subjects with inalienable rights, and these are life, liberty, pursuit of happiness. This is relevance 1. We can write another relevance in French Revolution, whereby French revolutionaries observed that men are born free and equal in rights, and they say that aim of every kind of political institution is to preservation of rights of man. What are these rights of man? Liberty, property, security, and resistance to oppression. This is the idea behind French Revolution, right? Again, very naturally, they have written this. By naturally, I mean by reason, right? Then we can find relevance in Constitution of India, fundamental rights. Fundamental rights have 32 rights in it. So rights have a lot of importance that way, right? So relevance is where is in American Revolution, French Revolution, Indian Constitution. We find relevance of rights, relevance of natural rights, right? But this theory of natural rights, based on reason, was criticized by a lot of a lot of traditions within political science. So the criticism of criticism of theory of natural rights. Criticisms of theory of natural rights. First criticism was given by none other than feminists. Feminists give first criticism, and feminists say that the language which the revolutionary used was masculinist, right? Was masculinist. So what French revolutionaries wrote was, right? I will write that quote or write that declaration. Uh, uh, Verbatim, again translated in English. French Declaration of Rights of Men. French Declaration of Independence was like this, or post-revolution they wrote this declaration that said French Declaration of Rights of Men and of the Citizen. Right, rights of men which are citizens. And French Declaration of Rights starts with men are born and remain free and equal, in rights. So feminists naturally questioned this declaration, which only mentions men. Does women have any place in that declaration? Does rights of men, does rights of men as written by French revolutionaries, does rights of men include rights of women? That is the idea. Feminists question this. That is the idea behind feminists. So so who questioned this? Who questioned this? Again, mother of feminists. Who was mother of feminists? Mary Wollstonecraft. Mary Wollstonecraft. Stonecraft, mother of feminists, questioned this, whereby she asked, "This men are born free and remain free and equal. Does this statement include women?" So feminist criticism, again, very deep criticism by asking, does this statement include women? Then conservationists also criticized natural rights. Conservative criticism also followed. Conservative criticism. What is conservatism? What is conservatism? When when you don't understand a particular word, try to understand and try to remember examples. Right? नहीं नहीं आवाज नका करू फक्त बाकी करा तुम्ही फक्त आवाज नका करू दोपहर में करतो दोपहर में ठीक आहे 35 what is conservatism conservatism led और मैं ठीक है मैं फिर से शुरू करता हूँ conservative criticism to natural rights to understand conservatism always remember examples to understand any word always remember example right example of conservative is Aristotle. Plato talks about complete radical change. Aristotle talks about piecemeal change, right? He wants to maintain status quo. He wants to maintain status quo, right? He wants to maintain status quo. What does this mean? That the institutions need to be preserved. Institutions need to be preserved. Changes has to be gradual, not sudden, right? Changes have to be gradual, not sudden. Sudden break of tradition should not be there. Wholesale change should not be there. Right? Plato proposed the system to be entirely changed. Aristotle said no, we have to maintain institutions because institutions represent collective wisdom of ages. Right? So this is basically conservatism. What would conservative people criticize? Right? What would conservative people criticize rights on? Conservative people will criticize rights on complete radical change. So there is this conservative known as Edmund Burke. Edmund Burke criticized French Revolution. Edmund Burke criticized French Revolution because French Revolution led to sudden wholesale change. Within days, within days, France turned from monarchy to democracy, a republic. Within days, people of France, which did not have enough food to eat, suddenly changed from we don't have to eat to saying that all men are free and equal. Right? Sudden change is there. So he criticized French Revolution, but he did not criticize Glorious Revolution. Glorious Revolution, revolution of Locke's time. This was constitutional revolution. This was bloodless revolution. Right? The the power was transferred from king to parliament with relative ease. So gloriously in Glorious Revolution, we see piecemeal change, a small change, right? We see continuation of tradition, right? We see small continuous change. We do not see sudden break from tradition. We see the institution of monarchy is still preserved. Still new changes are there, like parliamentary power, right? So say, Burke as conservative say, institutions represent collective wisdom. Institutions represent collective wisdom. This collective wisdom needs to be preserved because some there is some thought behind it. There is some reason behind it, so as to as such institution exist. So he says customs and traditions are better source of rights than reason. Reason can change, morality can change. Customs and traditions are a better source of right because they haven't changed in long time. If someone is talking about customs and traditions and not reason, because reason is constantly changing, then that person is communitarian, because customs and traditions are of community, they belong to a particular community. So this theory later influenced communitarian theory of rights and cultural relativist as well. What is communitarian theory or what is cultural relativist, we are trying to understand when we'll study that. But we can see influence of Burke, whereby Edmund Burke says that customs and traditions are better source of rights than reason, right? And he calls rights based on reason, that is natural rights, he calls natural rights as metaphysical abstractions. Edmund Burke. He calls natural rights as metaphysical abstraction. Why metaphysical abstractions? Because they don't reflect themselves in reality. They don't reflect themselves in reality. However strong your reason is, if that reason does not align with society's customs, such reason cannot be and will not be applicable within a particular society. I always give example of child marriages in Rajasthan. To our reason, child marriages in Rajasthan are absolute folly of human character for us. But for people there, that is their custom, right? For people there, that is their custom. If we apply our reason, child marriage is wrong. But for them, child marriage is correct with respect to customs, right? With respect to child marriage in Rajasthan, we are just metaphysical abstractions. We are applying ideas in such a situation, in such a context, which is not ready to accept those ideas, and they remain ideas only, right? They remain ideas only. Law is an idea. Child marriage, prohibition of child marriage is a law. Rajasthani people don't accept it. They do not accept reason behind those laws, and they say we will continue with child marriages. For Rajasthani people, child marriage is a metaphysical abstraction. For them, their customs are more important. Their customs are more important. Then the third criticism, we have seen two criticism. First, feminist criticism. Second, conservative criticism. Feminists criticized because there was no mention of women in French Declaration of Rights of Men, we have seen conservative criticism because Edmund Burke says that natural law, tradition of natural law, changes a lot of institutions suddenly, and he calls them metaphysical abstractions because such ideas do not find place in real world. That is the idea. And the third criticism was given by legal or utilitarians. Utilitarians theory of rights. By reading the word utilitarian, who is the first person that comes to your mind? It has to be Bentham. It has to be Bentham. Bentham Bentham is a savage, is a stud, and he criticizes everything that is natural rights. His language is like uh, crazy language he uses. He says he says natural rights is nonsense upon stilts. What is stilts? Handicapped people who cannot use their legs use those supports when walking. That is stilts. So it is nonsense upon stilts, that it has no backing. It has no backing. Such nonsense which has no backing is nonsense upon stilts. He calls them nonsense. Cripples use stilts. They cannot walk by themselves, so they use two uh, two two stilts to give them some foundation or some support. So Bentham calls natural rights nonsense upon stilts. He calls natural rights to be chimeras of imagination. Chimera itself is an imagination. Chimera is basically imagination. So he wants to say natural rights is imagination of imagination. It has no meaning. And natural rights, he say, it is a language of terrorist. Natural rights, he say, is a metaphor. Natural law, he say, is a metaphor. And natural rights is based on natural law. That is why natural rights are based on metaphor of a metaphor. Right? Metaphor of a metaphor. Natural rights are metaphor based on metaphors. All these things he said in his book Principles of Legislation. So the most penchant, the most uh, detailed critique of natural rights was given by Bentham, whereby he calls natural rights to be metaphors and natural rights to be metaphors based on metaphors, natural rights to be nonsense upon stilts, metaphors and language of terrorist chimeras of imagination. For him, for him, natural law is not real. For him, natural law is not real. For him, positive law. What is positive law? Codified law. Codified law is real. If positive law is real, codified law is real. That is why for him legal rights are real. He does not believe in natural rights, he believes in legal rights. Right? You can see that Hobbes called covenants without swords. Covenant without sword. That quote of Hobbes is fitting here. Covenant without swords. Without backing of sword, natural law is is nothing. Like law is nothing. Natural law, he basically criticizes natural law by calling it covenant without swords because it has no meaning. It cannot be enforceable. So natural law Bentham criticizes. Positive law he supports because positive law can is codified. Positive law is legal right. Legal right can be enforced. Natural law, as long as they are not codified, cannot be enforced. Natural law are covenant without swords. This was Hobbes' quote. That is why he supports theory of he supports legal rights and he supports positive law because natural law cannot be enforced. In continuation of his criticism, he says natural rights are terrorist language. Why natural rights are terrorist language? Because suppose I give suppose I give right to education to everyone. Suppose I give not right to education. Suppose I give, let's say, universal basic income to everyone. I say all of India, I will give 1000 rupees to everyone's bank account in every month. Is Indian state capable of doing this? No, Indian state is not capable of doing this. If Indian state is not capable of doing this, it will lead to anarchy. We cannot we cannot propose something. State cannot propose something and or state cannot give something which it cannot fulfill. When state promises something and it is not able to fulfill that, then it leads to anarchy, right? Then it leads to anarchy. That is why he says that natural rights are terrorist language it demands it demands something which cannot be fulfilled by state. If it is not fulfilled by state, it will lead to anarchy, right? That is the idea. The next criticism of natural rights was given by Lasky in his book Grammar of Politics. Pluralist criticism of natural rights, right? Pluralist criticism of natural rights. Not he does not criticize natural rights. Sorry, he criticizes legal rights. Lasky in his book Grammar of Politics criticize legal rights, not natural rights. Keep this in mind. I am just teaching because it is in continuation of the topic. So, pluralist criticism of natural rights. Lasky criticized natural rights in his Grammar of Politics. He says that legal rights legal rights are are telling factual position, but with respect to political science, they are not relevant. Legal rights, he say, is is within boundaries of law, discipline of law. He says with respect to political science, we have to discuss natural rights. Barker also says that Barker says that as legal rights draw its source from monastic sovereignty. Legal rights draw their source from monastic sovereignty Barker criticizes legal rights and says that there cannot be a single source, single basis of rights. So this was basically natural rights, criticism of natural rights, and legal rights and criticism of legal rights as given by pluralists such as Lasky and Barker. We are finished with natural rights and legal rights. We'll jump to Marxist view, and later in Marxist view, we'll try to cover libertarian theory of rights as well, and we'll jump to multiculturalism and and human rights theory as well. I hope this helped. We'll continue from the next lecture. Thank you so much. Bye bye.